Good morning. Is this a great day or what? I love all the conversation. Welcome to Oliver Van Dyke Insurance. We love having you in our home. So thank you for coming. Glad you're here. Will you please just imagine yourself as our guest for today in our home? We love that you're here. We have an action-packed morning. My name is Bruce Waldecker. I'm in the benefits department on behalf of our team. Glad that you're here. A couple housekeeping items. We are being recorded for all posterity. If you need the restrooms, we have restrooms on the other side of the steps, or go downstairs. There's restrooms downstairs as well. If you have any questions, you'll notice that some of us will have this name tag or name tags with the red stripe. They're part of the Oliver Van Dyke Insurance OVD staff. All right? And we will have an hour presentation. We'll take a break, another hour presentation, then we'll do questions after that. All right? On your table, you have some index cards. Feel free to write your questions down there just so you don't forget. The question and answer period, when we get to that point, will be just shouted out. All right? They'll take general questions. They'll hang here as long as they can hang here. All right? And if need be, they'll separate into individual questions as well. All right? Our next summit is April 12th, risk transfer. If you go to our website, ovdinsurance.com/summit, you'll find the entire schedule, and you can also sign up for those even now. We are adding some additional summits between those, and you'll get the invitations as well. Are you ready to get started? Bruce, stop talking. Introduce the guests. Let's do this. Now, Keith and Andrew, they have huge bios. And do you like it when somebody reads that bio for 10 minutes? No, they don't either. All right? So we're going to keep it short. Keith Eastland, both Keith and Andrew Cassini are from Miller Johnson, so thank you to Miller Johnson for coming. There's just one thing that I noticed with Keith. He's a Navy man. All right? So maybe he'll tell you some sea stories, maybe not, I'm not sure. When it's Andrew's turn, I noticed he was a Michigan man. And he'll probably tell you some stories from that as well. But without further ado, Keith, why don't you come on up and get started? So thank you. You can help us welcome Keith. You are all set.
All right, well, thank you, Bruce, and thank you to everyone for coming out this morning. We're excited to be here, right? And I got two words to say. Holy smokes. Holy smokes. Marijuana, recreational marijuana, is legalized in Michigan. Voters said so. How many of you smoked a doobie or ingested a brownie this morning? Come on. Maybe one. Okay, I know you're not being truthful. And the reason I know you're not being truthful is because you're here for 2 hours of seminar, 1 hour of which is to listen to a lawyer talk about paid sick time. So you must be high, right? So I drew the short straw. My friend and partner Andrew is going to have the fun stuff on the second part of this. But I'm going to spend some time going through the new Michigan paid sick leave law and try to answer some general questions through the materials. We'll take about 45 minutes to an hour, and then we'll have time for questions at the very end. So we'll break. Andrew will do the marijuana piece, and then we'll have time for questions for everybody, for both of us. And then we've also, when it's all finished, Andrew and I can both stick around, and I'll have time to talk about specific paid sick leave questions, because I got to tell you, some of the answers we just don't know, and it's really unique to each individual organization. So without further ado, I am going to briefly talk about the minimum wage first. So on the minimum wage piece and the paid sick law leave, how did we get here? Well, last summer, you may remember there were two voter initiatives. One was to advance the minimum wage to $12 an hour over time, and then tie that to the consumer price index so it would automatically increase every year. The other one was for paid sick leave. It got enough signatures, both went on the ballot, okay? When a voter initiative gets approved, you have enough signatures and it gets approved by the appropriate agency in Lansing. There's two ways it can become law. First, it can be approved at the ballot box. We go in just like you did for marijuana. If you voted yes, voters approved it. If it gets approved by the voters, to change that law requires a supermajority in the legislature. Okay? The second way to do it is the legislature can say, well, the voters have enough signatures, we're just going to adopt. We're just going to adopt it and it becomes law. Okay? So what happened was, once the signatures were sufficient, the Republican Congress, or not Congress, legislature, sorry, I think of federal, adopted what was called a adopt and amend strategy. And so what they did was they said, fine, we'll adopt these as is, so they become law. But in the same session, they said, but you know what, we're going to amend them. We're going to amend them to take some of the teeth out, to change them up so they're more business friendly. It was adopt and amend strategy. It was a little controversial at the time. Bill Schuette, who was the Attorney General at the time, issued an opinion saying that's perfectly constitutional. And we're going to talk about that later. And then the governor signs it. So both of these initiatives, as amended under the new law, become effective March 29th. Okay, that's the date you need to know. So minimum wage, what are we talking about? Where do we end, right? I like to talk to clients when I sit down to have a meeting. It's like, okay, let's start at the end. It's just easier to start at the end. Well, here's the end. We're going to go to $12 an hour as of 2030, okay? Which is a lot later. It's about 8 hours later than the voter initiative would have. Okay? We're not going to have automatic increases tied to consumer price index. Okay? It's just going to be set triggers each year, set increases each year. Okay? And if for some reason our unemployment rate skyrockets 8.5% or higher, then the incremental increases in the minimum wage will not take effect. And I think this next slide's great. And this is all in your materials too, but this shows you the difference, right, between what on the left side was the voter initiative and what the law that was amended and passed and what will take effect on the 29th of March is. So you can see the step, it's a much more gradual increase over time, and you get to $12.05 by 2030 versus 2022 at $12 an hour. So this was, depending on how you view it, but a lot of businesses think this is a good thing. So that's kind of how we are on minimum wage. So straightforward. Biggest thing, most immediate thing you need to know is 20-cent increase if you have minimum wage workers. 20-cent increase effective March 29th, going from $9.25 to $9.45 an hour. And that was the minimum wage piece. So let's talk about the really fun stuff. Paid sick leave. Okay. This is the roadmap we're going to cover today. First, you got to know, is my organization covered? Do I even need to worry about it? Okay, that's the first thing. Second thing is, if I'm a covered entity, if this law applies to my business, who gets this? Who's an eligible employee? We're going to spend a lot of time talking about that because that's where a lot of the issues come up. The requirements, the third thing I'm going to talk about in my hour here is, okay, what are the general requirements to provide? How much leave? How do you pay it? That sort of thing. And then we're going to talk about some different options, and you probably already likely know there are two options, really. You can front load or bank 40 hours on the front end for eligible employees, or you can accrue it as 1 hour for every 35 hours work. Okay? So those are going to be your two options, and we'll talk about both of those. And lastly, we'll talk about existing policies. Okay, who's covered? Does it apply to you? It applies to you if you have 50 or more employees. That means any employees, not eligible employees under this act. It's any 50 employees. And what the law says is if you're required to withhold federal income tax for the employee, then they're counted. So that's how you count up to 50. If you hit 50 or over 50, you're covered. Now you're thinking, okay, what if I'm right around 50? I'm about to hire 3 more people, but they're only going to be here for a month. if you're familiar with the Family Medical Leave Act on the federal side, the test there is you have to have 50 employees for at least 20 work weeks in the current year or the preceding year, so in the last 2 years. The legislature didn't tell us anything here. They just said 50 employees. So if you hit 50 employees for a month, you got 51 employees per month, and then you go back to 49, does that mean that you're covered? We don't know the answer to that. Okay? What I can tell you is, my advice is, if you're fluctuating like that, you probably aren't covered. I don't think that's the intent of the legislature. But if you are over 50 for any meaningful period of time, 6 months or more, you probably ought to think about really complying until we get an answer. I know that may only affect a few of you in the room, but that is an unanswered question that we've been getting. All right, so that's coverage. So let's talk about eligible employees. Okay. The way this act was put into place or worded is everybody's eligible, and then there are 12 carve-outs. Okay? So every employee that you employ is eligible unless they meet one of the 12 carve-outs. Okay? The first carve-out is a huge one. Okay? Anybody that's exempt from overtime minimum wage laws under the professional, administrative, and executive or outside sales exemption, right? So if you've got people that are paid salary and meet the duties tests, right, under the FLSA, they're properly classified as exempt, and they don't get this benefit. Okay, so that's a big chunk of people. That's the first one. Okay. Private sector employees covered by a collective bargaining agreement in effect. What are we talking about? Unionized employees. Okay. This is an interesting one. By show of hands, do I have any unionized folks here? None. Okay, so you don't really care. Great. That makes that easy. But if you become union, well, you might want to know because that's your competition, right? So basically, if you have a current collective bargaining agreement in effect, a labor contract in effect, our view on this is it's in effect, so it's grandfathered. So you're good through the end of your current labor contract. I do not think that this is an exclusion for all unionized employers. Right? I don't think unionized employers are going to get the benefit of not having to comply with this. And the reason is because it says in effect. Well, a contract's always in effect, right? So the only way to give meaning to that part of the statute, in my view, is to say in effect now, right? It's implicit in it now. So that's one of the issues that's going to shake out. I think they're going to get a grandfathered pass. I don't think that unionized employers are going to be exempt from this for all time. Individual employed by the United States government, another state, political subdivision, that's self-explanatory. Flight deck or cabin crew employees of an air carrier, again, probably a very unlikely that that applies to anyone. Same with Railway Labor Act employees, they're excluded. This is the student wage. If you have any folks that are covered by the Workforce Opportunity Wage Act, the training student wage, they would be excluded. Okay. If you have employees who work outside of Michigan and that's their primary location, they're excluded. They're not eligible. Okay? So if you've got an office in Ohio, whatever, and their primary work location is outside of Michigan, then they're not going to be an eligible employee. They'd still count for the 50, right, for coverage, but they wouldn't be eligible to receive the actual paid leave benefit. Everybody with me? You're like, where's my marijuana? I think it might be over there. The next exclusion from eligible employees is what I would call kind of your seasonal, your summer folks. Okay? And there's two parts to it. If you employ someone for 25 weeks or fewer in a calendar year, okay, so they actually work 25 or fewer weeks, and the job is scheduled for 25 or fewer weeks. So if you hire a bunch of summer folks, right, you better make clear at the front end that this is a job for less than 25 weeks, right? Because it's not just, hey, they're only here for 15 weeks, so I don't have to worry about it. On the front end, you have to make clear that whatever job you're hiring them for is only planned or scheduled for 25 weeks. If you do those two things and it's documented, then those folks would be excluded and they would not be eligible for this benefit. Variable hour employee under the Affordable Care Act. Anybody have experience dealing with that? A few of you. I'm not going to get into the details there because my partner, Mary Bauman, some of you may know her or heard her speak. She gives 2-hour seminars on the compliance with variable hour employees. I'll explain it this way. If you have employees where their hours fluctuate, they vary, you can't know how many hours they're going to work, if you apply that test to them and you meet the test under the federal ACA for the Affordable Health Care Act, then they're excluded. Okay, so that's a separate analysis, but for those variable folks, and we can walk you through that process if you have those kind of folks, but they would be excluded as well. Okay. And the last one on my slide 15 is, I'll call it the part-time exemption. Okay, so if, or exclusion, I should say, if the employee works on average 25 hours per week, less than 25 hours per week in the year, in the calendar year previous, if they're less than 25 hours, they're excluded. If they're 25 or more, they're included. Make sense? Okay. And so that's the math part. So let's kind of go through this. I'm going to go through some examples. In your materials, you should have this. If you really can't sleep or cause yourself some pain, headaches. No, in all seriousness, we have got 3 lawyers in our firm that are doing a lot of this, and we got together and we put a little flow chart together to kind of help you. I'm going to walk through some of this by slide, but this is a nice little reference you could take with you to kind of do the analysis when you're sitting in your office if you have questions. But the first question it comes up is, okay, what about known regularly scheduled employees? Okay, these are easy. If you know someone's going to be 25 or more hours, you give them the benefit. What about new hires? We don't have a calendar year to look at. So our advice on new hires has been, if we anticipate and reasonably expect them to work more than 25 hours, then you give them the benefit. You bank it or you accrue it, whatever you decide, you do it on the front end. If you're a little unsure of that, okay, if you're a little unsure of that, okay, so well, let me go back. So if you're unsure of that, there's this provision in the law that says that for eligible employees that are newly hired, you don't have to let them use the paid leave for 90 days. So if you're a little unsure, you can actually use that 90 days where you don't have to allow them to use the leave as a mini look back period. And so at the end of that 90 days, you can look back and say, did they actually go over 25? And if they did, our recommendation is cover them and then cover them retroactive to the day they were hired, right? Because they couldn't use it, but if they banked it or they accrued it, right? So it's kind of a legal fiction, but that's a good way to do that, and that's something to take note of. So a little harder question I would say is, if they're less than 25 hours, okay, obviously if we don't think they're going to work the requirement, then you're not going to give them the benefit, okay? But again, you can use that 90-day period as a check, right? If you think it's close, or you hire someone that looks like they start working a lot of hours, you got to look back after 90 days and say, yeah, we hired Keith to work 20 hours, but he's really working 28. Let's make sure we get that right, okay? If the employer averages 25 hours a week, provide paid medical leave, that's all self-explanatory. Makes sense? All right. Transfers. Transfers are easy, I think, if you are transferring into a position where it's above 25 hours, just give them the leave, right? It's like a new hire. The harder question is, what if I start 2019 in a 20-hour-a-week position, and in July, I decide to go full-time? Well, I was an eligible employee for the calendar year 2019 for at least 6 months, right? Well, what do you do on the back end? Do they not become an eligible employee because they transferred to essentially a part-time position? And I think the law is unclear on that, but I think there's a good argument that you do have to continue to give them the leave for that calendar year. because this 25-hour threshold is based on the prior, everything's based on a calendar year when it comes to this eligibility exclusion. So what we're suggesting is that if they come out of a covered eligible employee position and they move to a part-time position, then you treat them as eligible just for the remainder of that calendar year. Make sense? Seasonal temporary. Again, two components that I talked about, right? It's that the planned job duration is 25 weeks or less, and the actual length of employment. Okay? And this is all, there's a nice little flow chart here that walks you through all of this again. Make sure both apply. You can't determine whether they're expected to work on average. That's a little bit harder, right? If they got variable hours, that's when you're going to have to do this ACA test, which I don't want to get bogged down in it this morning, but it's complicated. If you've done this analysis, you know it's complicated. There's like an initial measurement period, and it actually uses a different threshold. It's 30 hours instead of 25 hours, so it's a little more complicated. Ongoing monitoring. This is an interesting issue in the sense of you're going to have employees under this new law that get a benefit and potentially lose it year to year. So 90% of the people, it's easy, right? If you're over 25, you're going to be covered. At the end of the calendar year, you look back. So at the end of 2019, you're going to look back and say, did Andrew work more than 25 hours a week? Yeah, he worked 30. So he gets the benefit for 2020. But if he didn't get it, right? So if he didn't meet that, then he could lose that benefit. So you could see from year to year, employees could get things and lose things, right? Which is never any fun, because once people get something, they sort of get used to having it, right? Entitlement. So that's an interesting part of this. Okay. So what do you have to give them? You have to give them, what the law is designed to do is to have you give them 40 hours of paid sick time, okay? Paid leave. But one really good thing about the amended version of this is you can give them paid time that, as long as it can be used for paid sick leave reasons, if it can be used for other reasons like vacation, like PTO, as long as you give the 40 hours of paid time that the employee has the ability to use for sick leave, that's sufficient, right? So if you're already giving employees 40 hours of paid time off, vacation, as long as you modify your vacation policy to say you could also use it if you want for these reasons as set forth in the state law, you're compliant, which is a huge thing for employers, right? That's huge. Because now what are we really talking about? We're really talking about people that maybe are in your first year that haven't qualified for vacation, those sorts of things. So that's a really big part of the amended sick leave act that you have to remember. So it's not like you have to have a separate bank of 40 hours for just sick leave. Okay? You can combine it with your PTO, with your vacation. And that's a huge takeaway today. If you didn't know that before you came in, that's very important. So it's not like you have to have a separate benefit. And you can make up any benefit year you want it to be. So whereas in the eligibility world, when you're looking at 25 hours, averaging 25 hours or more a week, that's on a calendar year basis. Your benefit year, when you decide to provide the benefit or start accruing or bank up, which we're going to talk about in a second, that is a benefit year that you can determine. So if you want your benefit year to be the calendar year, you can do that. If you want it to be your fiscal year, you can do that. And that's up to you, your benefit year. It's any 12-month period. And some employers we deal with actually have individualized by the employee your benefit year. Okay? You can do that too. It's an administrative burden, but some folks do it. So if you have that, you can do that as well. What do you have to pay them? You have to pay them their straight time rate. Okay? That doesn't include their overtime. It doesn't include any premium pays. So if they paid hourly and you pay them $20 an hour, then that's what they get when you pay the sick time out. Okay? If for some reason you wanted to pay the minimum wage, you could. But you have to pay the higher of the two. Actually, you couldn't. You have to pay the higher of the two. So pretty straightforward. If you have salaried folks who are not exempt, okay, you got to figure out their hourly rate. So whatever they reasonably work, as long as you have some measure of that, just work it out to make sure that you've got a defensible position on this is the hourly equivalent of the salary amount. Because remember, just because you're salaried doesn't mean you're exempt. We have people that are paid on a salary basis that don't meet the Fair Labor Standards Act duties test, in which case they would be eligible employees. Let's talk about the uses here. So this is different than family medical leave. If you're familiar with the FMLA, you got the serious health condition, you got to get a certification. It's more stringent. This is a lot looser, okay? And you can use it for the employee's own mental or physical illness, injury, or health condition, a medical diagnosis, care, or treatment of employees' mental, physical illness, okay? Preventative care. Well, I want to go to the dentist because I have access to, right? I just need to go get a consult. I can use it for that, right? I want to go get preventative medical care. I just want to get a screening. I get, diabetes runs in my family. I want to get an annual screening. You can use it for that. It's paid time off, okay? So much broader. Family member, same reasons for any family member. And family member is defined by the statute. I never remember it, so I'll read it to you. So your family member includes biologic, adopted or foster child, stepchild or legal ward, parent, foster parent, step-parent, adoptive parent, legal guardian, grandparent, grandchild, biological foster sibling, and that's basically it. So pretty broad use. There's some domestic violence and sexual assault provisions. I'm not going to spend a lot of time on these because you can read them, but you should be aware of them. If people are involved in a sexual assault, domestic violence issue, they need to see a lawyer, they need to go to court, they need to go get a PTO. Those sorts of things can be qualified for them to use their paid leave. Same thing with this exception, or this exception, use of, for the paid medical leave. If there's a public health emergency, this is a serious thing, you're going to know it. I just want you to keep it in the back of your mind that could trigger an employee's ability to use paid medical leave. Great part of the law as well is Michigan legislature said you get to enforce your reasonable and customary notice requirements. So I don't just get to take leave. I have to follow whatever it is you require people to do to take time off. So if you require them to give you notice in writing, you can require that. And if they don't comply with it, you can discipline them. Okay. What you can't do, I don't think, and this is an open question, is I don't think you can deny the leave. If the leave is for a legitimate reason and they don't follow your policies that you have in writing, you got to notify your supervisor, you got to call in, whatever it is, and they don't do those things, I don't think you can deny the leave. Okay? Because it doesn't say that. It just says that you can be disciplined. Okay? So that's important to know. But it's also a good thing that you can require them to comply. If you're going to require documentation of the use, so if I'm going to my dentist or I'm going to see a lawyer because I was in a domestic assault violence issue, you have to give them at least 3 days. Okay? You have to give them at least 3 days to provide the information, and then there's some things that are sufficient. And here's what I would say. You got to treat this leave like you do every other leave. And some things are going to be foreseeable, right? And some things aren't, right? And so if it's an unforeseeable event, you need to treat the unforeseeable event covered by this new law like you would do any other unforeseeable event. So if you would excuse your notice requirements, as you probably should, right? If it's unforeseeable, then you should excuse it here. Just apply it consistently. If you receive health information, you would do this anyway, or information related to domestic violence, assault, you got to keep it confidential. It goes without saying, I think, but you need to keep it confidential. Okay, what record-keeping requirements are there? So the record-keeping requirement is that you need to keep track of the hours worked and the leave that you've provided for these folks for at least 1 year. My recommendation is do it for 3 years because you got to do employment records for 3 years generally. So just treat it like every other employment record. Okay. And then Laura's entitled to look at that at any time on reasonable notice. And there is a posting requirement. So if you do your own posters, or if you get them through the chamber, or wherever you get your employment posters, make sure they include the new posting for this law effective March 29th. Laura's got it. It's up on its website. If you need it, we can get it to you. Posting requirement. Okay. So let's talk about your two options to comply. So they're really, you have the accrual system and what is the load or the bank system. So if you look at the accrual system, it's got to be at the rate of 0.029 hours worked. Okay, so that's 1 hour for every 35 hours worked. But you can limit that to 1 per week. Okay, so that would be 52 for the whole year. Except the law also says that you can limit the accrual to 40 hours per benefit year. So you can cap it at 40. But you have to allow them to accrue that 1 hour based on hours worked, and you got to track it, okay, and up to 40. Okay. And you're also not required to allow someone to use more than 40 hours per year. So when might this be attractive? You think, well, geez, that seems like a burden. It might be attractive if you've got a group of employees who you're going to give. If you were to give them a bank of hours up front, they might abuse it. Right? If you want employees to have to earn it and you're willing to keep track of it, and some people that I've talked to like that because it makes the employees feel like, yeah, I'm earning that. And I don't want to just use it willy-nilly because it makes me feel like I have to earn it. It's a benefit I've got, and therefore I'm more likely to use that when I really need it. Whereas if you bank it up front, I suppose, if you're worried about that. But again, this isn't that big of a big deal if you've got 40 hours of paid time off for other things. So it may not be a huge deal for your organization at all. So that's the accrual system. The load system or the bank system is at the beginning of the benefit year, whatever benefit year you choose, you just got to give 40 hours up front. Just put it in a bank and let them use it. And again, as long as it can be used for the purpose of the sick leave that we went through, you're good. Even if they want to take it as vacation, that's fine. They don't get more than 40 hours if they took the vacation. Okay? And you can prorate it for eligible employees hired during a benefit year. So if you give 40 hours, you give 50 hours, and they come in halfway through the year, you just bank it at 50% upfront. That make sense? An important point here, you can apply different methods to different groups of employees. So if you want to pick the load system for 85% of your employees, you can, and if you've got a small group that you want to accrue for, you can do that as well. So you can pick, you don't have, it doesn't have to be employer-wide. The law, as I see it, is kind of pushing people to do the bank or load system because there's some benefits to that. You don't have to carry over any paid medical leave to another benefit if you load it, bank it up front. Versus the accrual system, if you choose that, you have to allow someone to carry over the 40 hours in a year. Now, you don't have to allow them ever to use more than 40 in a year. Okay? You just have to allow them to carry it over so if they don't earn it, it's still there for them to use. All right. Use, we talked about this already. So an employee can use the accrued paid leave as soon as it's accrued. So if it's banked, obviously they can use it right away. If it's accrued, they can use it as soon as it's accrued, except during that 90-day period, right? So you can restrict use to being there for 90 days. One other point before I get to this is if somebody, no, actually I think I got it on another slide. I got that on another slide. How is it paid? How can they take it? Well, the law says you got to allow them to take it on a 1 hour increment unless you have a policy in writing that says you can only take it in a half day or a full day. Okay? So you have a lot of discretion here, but you got to have it in your policy. The default is they got to take it by the hour. But if you don't want employees to take paid medical leave by the hour, if if you have a policy that says all PTO, all leave, paid leave, has to be taken in half a day increments, you can do that. But it's got to be in writing. Okay? Unless it's in writing. So again, flexibility. We talked about this already. You're not prohibited from discipline or discharging an employee for failing to comply with your usual and customary notice requirements. Again, this should be in writing, right? Whatever your usual and customary requirements are should be part of your policy. This is the point that I was going to make, but I had a slide on. You don't have to pay this out ever, okay? So if someone leaves your employment and they have 30 hours of paid sick time, you don't have to pay it out. Okay? If your policy says you're going to pay it out, you have to. Because we have the Michigan Wages and Fringe Benefits Act, which says that you have to follow your own policy. But nothing in this law requires you to pay it out. And if an employee quits or takes another job and then comes back and gets reemployed by your organization, you don't have to give them credit for prior leave. It starts again, it starts anew. So that's another nice piece of the changes. So let's see. At that point. All right. So how are we doing on time, Andrew? We good? Good. I'm flying. Sorry. I might have time for questions after all. Let's talk about your policies and kind of decision points as I see it. So the first is, are you a covered employer? You got to make that call. Assuming you are, now you got to look at your groups of employees. Who is going to be an eligible employee? Right? You got to look at those. I put them in groups. Figure that out. Based on who's an eligible employee, based on your existing policies on PTO and vacation, okay, what's the best way to go here? And in most cases, we're seeing it's just easier to do the bank load system. So you got to make that decision. And you got to make that decision for each group of employees. And every business is different and unique. You know, I had one client that said, well, you know, I've got folks that are seasonal, but they work 35 weeks a year. And I don't want to give, you know, somebody that works only half the year, essentially, a little more than half the year, the benefit. Well, you have to. Okay? So then their question is, for that group of employees who is kind of more seasonal, do I do the load and give them all the 40 hours? Because they didn't get full 40 hours of vacation. I think they got like 20. Do I do that, or do I do the accrual? And I think they ended up going with the accrual. But that's an example where you do need to think about this from the perspective of each organization and from the perspective of each group of employees. What makes the most business sense to do that? If you have the ability, and you do, to modify your policies everywhere you can under this act, make sure you do that. Make sure you put that in writing, take advantage of the things that the act allows employers to do. I want to talk about this. Anybody have no fault? No fault attendance? So a no fault attendance system, if you're not familiar with it, is when you miss time, we don't care the reason, we just give you a point. So I don't have to track anything. I just, you know, unless it's an excused absence, it counts. And once you get to so many points, you get a certain level of discipline. Under this new law, if you have a no fault attendance policy, people could miss time, and if you're not tracking it, you count that as a point against them. That's going to be unlawful, because if they used it for permitted paid medical leave reasons under the new law, you're taking adverse action against them for exercising their lawful rights. So if you have a no-fault attendance policy, you need to think about how you're tracking potential uses of this new law for eligible employees. Posting requirements, talked about that. Another great point of this law is there's a rebuttable presumption that employers in compliance with, that you are in compliance if you provide at least 40 hours of paid leave. Again, paid leave is more. That's great. It's a rebuttable presumption. Again, they're pushing people to use the load or the bank system. Okay? How does the employee challenge this? They have 6 months to file a claim with Laura. If Laura concludes that you violated this, you're going to pay a fine of not more than $1,000. per violation. All right, so I just went through all that stuff, and I'm going to tell you to, it all might change. And I'm not kidding. If you've been following the news at all, the new Attorney General, AG's office, has requested, well, there was a state senator that requested the AG's office issue an opinion on whether the adopt and amend strategy is constitutional. So we had the Attorney General Bill Schuette give an opinion saying it was. There was a 1964 Attorney General opinion from Frank Kelly that said it was unconstitutional. And so now we think that the new AG might go back to that and say, well, no, that's unconstitutional, in which case then we might actually go back to the voter initiative. I've looked at the opinion letters. I think that if this is constitutional, I could be wrong, but at the end of the day, I think this will stick. And another interesting development was that State Senator, I think it's Shirky, is going to request from the Supreme Court an advisory opinion as to whether or not this would be what the legislature did was constitutional. The Supreme Court doesn't have to take it. It's discretionary. So the Michigan Supreme Court can say, we're not going to weigh in on that. But the bottom line is no one's going to give you an answer by March 29th. So we're telling all of our clients, we got to comply with this law because you got to assume it's going to be the law. If it changes, if there's some reason it's not going to take effect, if there's an injunction, we will send out a client alert. You guys will sure get it through multiple avenues, and you can put the brakes on. But for now, you have to comply. I just wanted to make sure I pointed that out to everyone so I don't want to leave here and say, well, East one from Miller Johnson didn't tell us that this might all change. And then you hear it on the radio or Wood TV or whatever you watch in the mornings. I don't know. And there's talk about another ballot initiative. If this is upheld, some of the folks want more stringent restrictions on employers that were consistent with the voter initiative, ballot initiative. So there's talk of that as well. So put that out there. Bottom line, effective date, March 29th. Okay. If you've got questions at the end, I'm happy to talk to you about your individual policies. If you don't have a policy, we have prepared, Miller Johnson, our group has prepared sample policies from scratch. I can give you one of those. And then we also have some checklists that you can use in addition to the eligibility chart. We got a lot of resources. And then I also would direct you to, there is a Q&A on Laura's website. If you have questions as well, that's another resource. But that's the effective date. I'm going to turn it over to Andrew for the more exciting part of the presentation.
Perfect. Chief, thank you. This is great. Don't go anywhere. Our timing is perfect. Are you ready for maybe 10 minutes of questions? Then we'll take a 10-minute break, and then we'll come back to Andrew. All right? So you got it now. I'll give you the hook when we're at the end of 10.
Go ahead and shout out your questions for Carolyn.
We work with a trucking company, transportation. So our drivers are paid obviously by the mile. They're not paid hourly. Mm-hmm. Some are Michigan residents, some are not. How would this apply to?
Can you repeat that one too? Yeah. So the question was, it's a trucking employer. They've got employees that are some in Michigan, some outside of Michigan, and they pay them by mileage, not by the hour. Okay. So the first question is, are they primarily working in Michigan? If they're primarily working in another state, they're not an eligible employee. So you can carve out those folks. Okay. If they're primarily working in Michigan, then they would be an eligible employee because they're not overtime exempt, are they? No. So then the question is, how many hours are they working? Okay. But we should look into whether or not there may be an overtime exemption that fits that first exclusion, which we can do separately. But yeah. All right. Right here.
We're federal contractors, so my understanding is that we have to have separate vacation days from 6 days. Does that still apply on those?
Yes, because those are done by executive order, correct? So the federal requirements. So the question is, we're a federal contractor. We have separate federal requirements to maintain sick time separate from vacation. I think that was President Obama's executive order a number of years back. This state law would not trump any federal requirements. That make sense? Yeah. Well, you may get that change. You may get that change at the federal level, right? Because remember, just as a matter of supremacy, the federal law will always trump the state law.
So, to follow up to your question, if not all of your contracts are federal, but you do have federal contracts, are you still held to the federal contract?
You don't have to look at that executive order to the scope of it, but I'm pretty sure that federal the requirements are only apply on the federal contract work. I think there's a carve out for that. So, but I'll need to look at that again because it's been a while since I looked at the federal contracting executive order. Back there.
I have a question about the paying out time and whether they quit if that time is paid out to the state and policy manual. We have it in our manual that PTO is paid when they quit. But is it have to be separately then, or is that all of this has to be paid out?
So the question is, if you have in your written policies now that you pay out vacation or PTO when an employee departs, does this have to be carved out separately? If you're going to roll it up into PTO and take advantage of the right to do that, then you're going to have to treat it the same way. You're not going to be able to do that. So, now, you may want to revise your policy about whether you pay it out. One of the things I advise when I look at handbooks or policies like that is that says we will pay this out if you give us 2 weeks notice and we don't think you're going to a competitor, that sort of thing.
You mentioned the idea of making sure you track the what's called paid medical leave from the employee, but is that also part of how they request it? Is that how we should do this? Otherwise, you're getting into why are you taking leave?
Correct.
So that we can actually track it.
Right. So the question is, we should track this. Maybe how should we do that? And should we do it on the front end? And I think you should, right? I think you should have a form that somebody can check that says, I'm taking this for a reason covered by the Michigan Paid Leave Act, and you can have a separate attachment that you can give employees and are available on your website that they can look to see all the covered reasons. Have them represent to you that is why they're doing it. And if you also want to check that on the back end, you can require the documentation as long as you give them 3 days, right? And then if they lie about it, obviously, then you can discipline.
So to go along with that, if you're rolling it into your current PTO vacation plan, do you have to track it specifically for medical leave? Or as long as you're giving them all their hours and they use it all, then it's fine? Or do you have to specifically track when it's for this?
You don't have to specifically track when it's for this. If you're going to say you can use it for this, you're good. And how they use it doesn't matter to you, then you don't have to track that. But you also can't, it goes back to the no fault. If you have a no fault policy, it's a little different. Then you do need to track that reason.
Along those lines, can you force employees has accrued time, they call in sick, and they say, you know what,
Yeah.
I'm going to use time for that, and employers say, no, you're going to use some of your time for that.
It's an excellent question. I'm glad you raised that. And the question was, can we force people to use the paid time off? The answer is yes. If it's in your policy and you could say, I want to use this time off, we could say, well, you need to use your other paid time off. Yes, you can do that.
Well, if you're going to force them to use it and say they use your whole bank, then they come back and say, oh, I need a paid medical leave, but my whole bank is gone.
No, because they've exhausted their bank, right? If you give them 40 hours, they've used 40 hours, and if they used half of it on vacation, and they're like, well, now I need more time off, right? I need a week off for surgery or whatever. Well, you can give them half of that paid. The other half, then we have to look at, remember, don't forget, you still have family medical leave, right? This is on top of Family Medical Leave Act, and it's on top of the ADA. So remember, leave as a reasonable accommodation, right? If you're in that world, and if an employee requests unpaid leave, and it's unpaid, so they could also be eligible for unpaid family medical leave if they haven't exhausted their 12 weeks and they're eligible, as well as if they need time off for a medical reason related to a disability, you have to, a reasonable accommodation is to give them that time. Okay? We're just talking about the paid portion of the, in the back here.
Going to the FMLA, can you force them to use the paid for the first part of their FMLA, because we have a lot of intermittent FMLA, so we can force them to use that time off at the front of it.
Yeah, a great question.
And
So,
the other one would be
right. So the question is, you know, this is common. You got a lot of intermittent FMLA abusers out there. And so the question is, if I'm on an FMLA certification, I'm using intermittent, can you require them to take that paid? And the answer is yes. If it meets one of the requirements, yes. You can say you're going to take that leave. It runs, you know, coterminously with the FMLA, but for those first, you know, 40 hours you use an intermittent FMLA, you're going to take your paid vacation, your PTO, and yes, you can do that. In the front.
If you have a vacation policy that's based on full-time being 30 hours, can you have two separate policies for the people that are working 25 hours? Or is your suggestion to back your vacation down to?
So the question is, what if our vacation eligibility is at a higher average hours than the law? Like the law says you have to give this PTO for average 25 hours per week. In your case, you're saying you have to work 30 hours a week. That's how you define full time. You can have separate policies, but do you want to? I would say probably not. Or what you could do is say, yeah, see, I think no. Now I think about it.
Your policy is 25.
Yeah, I think that
Front loaded. Now, follow-up question to that is, right now, our policy is after you've been there a year, you can use vacation. This doesn't.
right. So what?
Then can you have two separate policies?
Right. So that's a very good point. When I talked about that earlier, this great thing that you can combine your paid sick leave under the new state law with existing PTO and vacation, that's the gap that we commonly see, right? Is what about the new hires that aren't eligible? So for those new hires, if they're going to work more than 25 hours a week, I think you just take your vacation policy and you say, look, to get this, you have to be here a year and you have to average more than 25 hours. For new employees that don't meet these requirements, you are entitled to up to 40 hours for paid sick leave reasons for that first year until you qualify. So you don't have to give them vacation, right? Those newbies, I'll call them, for that first year, you just have to give them the right and ability to take the time for the paid sick leave reasons. And then you might even, for those folks, you might even want to require the documentation, right? So it doesn't require you to give the PTO and vacation to everyone in that group. You can carve them out. There's a way to do that. We can work with you on that language.
How about one more?
Here. Go ahead. In the back?
In the back.
That was my question. Do you have a current policy?
We'll go here then.
So if you take those new employees and you accrue them in that first year, but then you give them their 40 hours of normal PTO that they would have gotten under the current policy at our company, do they carry forward that 40 from their first year because you accrued it, or would you have to give it 40 in the bank in order not to allow them to carry that into their second year of employment?
That's a good question because, and it raises a good point. If you can't combine the methods, they're mutually exclusive. If you use accrual, you have to use accrual. You can't halfway through the year switch into the bank. If you use accrual for those employees, you got to use accrual for that entire benefit year. And at the end of the benefit year, you could switch over to the bank. But right, so to answer your question is, if they accrued all that stuff, but then you switched them to a bank, you wouldn't have to accrue it anymore because they're bank.
But do they carry it forward? So
No.
right now, a new employee gets 40 hours after 1 year of employment. But if we have 40 hours of the paid sick time in that first year, and we've accrued it because they might leave after 2 months. So we accrue it, and then we get to that 1 year point, the law says you need to
Allow the
allow
carryover.
the carryover. But at that 40 hours of their first year, we're now switching them to our 40-hour PTO system. So they still bring in another 40 hours of paid sick time if they didn't use it during that first year.
I think that there's a good chance that they would, because you made the conscious choice under the law to give them the accrual method, right? They accrued the 40 hours. The law says if you apply the accrual method, they get to carry it over. The fact that you changed your mind, I don't think it's going to extinguish their right to carry over. Now, I don't know the answer to that because that's going to be probably litigated, but conservatively, I would tell you, you would probably not want to extinguish their rights. If you wanted to take a little bit more of a risk and say practically it's not going to matter because we're still giving them 40 and it may never get detected, you're talking about 40 hours of time. But for the damages, they'd have to show that they were denied the right to use more than 40 in a year. So the detection risk would probably be low in that case. So
Well, that's a good one then, isn't it? Create some questions.
I haven't heard that.
Yeah, that's a good one. So thank you for that. All right, let's take a 10-minute break. Lots of food, water, coffee, that's been refreshed. There's an elevator just on the other side of this wall. If you'd like to use the elevator, there are some restrooms all the way to the end of this floor. More restrooms downstairs with lots more capacity downstairs. See you in 10 minutes. Ready, break.
Especially, I think you got the exact right number of questions, so that was perfect.
So I guess,
A lot of material.
well, you. Here we go. And. All right, welcome back. Is that one of those tricks where I have to speak softer? If I speak softer, does that mean it gets quieter?
I think it's working.
Let's,
Yeah, this is like an ancient teacher speaker right there.
Yeah.
That's amazing.
Then. So before I forget, on your way out, which is not quite yet, we have some candies. And there is the summit schedule for you to take. So those are on the tables on the way out. Isn't this great? That first session was wonderful. Andrew says he's even better than... He didn't say that, I'm making it up. Andrew, take it away.
Thank you. My name is Andrew Cassini. I'm an attorney at Miller Johnson. I practice with Keith. Keith and I work together quite a bit, and half the room is already alienated because you know now that I am a Michigan man. I will try to do better than Michigan did in the last basketball game and not make a row of 10 points within 10 minutes. But what we're going to be talking about today is a very timely topic, because this has been a news story that even if you weren't an employer, it could not possibly have eluded presence on your newsfeed. And that is, of course, recreational marijuana in the state of Michigan is now lawful. And well, I've been going around, I've been giving this presentation plenty of different times. I'm shocked and I'm surprised at the feedback that we've been receiving from employers who are desperate to learn more about this particular law. And I think that the reason for that is, if I can be candid for just a moment, I think that most employers have had a little dollop of insignificant treatment from the legal community. I think that you guys have kind of gotten the short shrift. And the reason for that, I think, is that when a lawyer takes a look at this particular law, there's one section in the law that says what your responsibilities are as an employer. And by and large, although I'll pick it to death a little bit because I am an attorney, by and large, that section says, whatever your policy says, you can do. So one answer to the question, how does this law going to impact employers, is it won't. Don't worry about it, and then they'll move on. I just heard a lot of laughter because I think that no one in this room is thinking to themselves, it's not going to be an issue. This is the classic example of a lawyer who builds a watch for you instead of telling you what time it is. And I want to rectify that a little bit today. So it is an honor to be able to present to you. And without further ado, let's get started. You can enjoy your brownies and gummy bears on the way out. I understand they are not fully loaded. Maybe. Maybe. Maybe not. Maybe we are not ready to get started. Maybe the tech guys already enjoyed the gummy bears this morning. That's one possibility.
Better or worse than the last basket?
There is a technical violation, so there you go.
Go ahead.
Hard to say. We'll figure it out. It'll be fine. Maybe it's if we actually maximize the thing itself.
This is where you talk.
Perfect. And I can tell you that. Shouldn't the millennial be able to figure out what you think overall? I can just do it manually with the back and forth arrows. That'll work. Or we can get it fixed. Congratulations. There we go. OVD insurance solves your problems, ladies and gentlemen. One of the reasons among many that you're here today, when you have heard that there's going to be a presentation about recreational marijuana, is you're here for hilarious stories. And I have one hilarious story for you that I have been using anytime that I've presented about drug testing many years in the past. So I hope that you guys haven't seen me present on that topic before, but I just have to read this to you. I want you to think back to 2005. That's the year. Mariah Carey had the #1 hit on the radio. We didn't know yet we needed to be disappointed by the ending to The Sopranos. 2005, the following news article appears on ESPN.com. May 16, 2005. The byline comes from Eden Prairie, Minnesota. Minnesota Vikings running back Ontario Smith, that gentleman right there, returned to the practice field Monday with little fanfare, and even less to say, after an embarrassing run-in with airport officials was made public last week. The news broke on Wednesday that Smith was caught at the Twin Cities Airport on April 21st, which is a hilarious date for him to be caught by the way. That's a 420 joke, ladies and gentlemen, with an elaborate contraption designed to beat drug tests. A search of the bag Smith was carrying turned up several vials of dried urine and a device called the Original Wizinator, which included a fake penis, bladder, and athletic supporter. An NFL spokesman said using the device during a drug test would be a violation of league drug policies. I would imagine so. But it is still not clear whether there are penalties for possessing one outside of a testing situation. Smith, who told police he was taking the vials to his cousin, which is an excuse that has never worked, was back in the field on Monday for a developmental camp but did not speak to the media. But the one person who did speak to the media, and we're skipping some of the articles here, is his quarterback at the time, a gentleman by the name of Dante Culpepper, who gave what I think is the best possible quote he could have given in these circumstances. Ontario, I love him like a brother, quarterback Dante Culpepper said. Just tell him you have to be straight. You have to think before you react and make decisions. He's a grown man. I can't tell him what to do. I'm going to support him and hopefully he makes everything right and takes care of his business. I didn't try to give him advice. I just told him, be smart. Try to make good decisions. I'm not judging him. I don't know what was going on with that machine, and I don't know that everybody should. Nobody knows what goes on with him and that machine but him and God. No, the real reason that you're actually here today, as hilarious as the Ontario Smith story is because of this. This is what happened. This is the result of the ballot initiative proposal 18-1 that occurred when we all voted back in November. And you will see that by an 11-point margin, people of the state decided that they wanted to enact this particular indirect initiated state statute. They wanted that to be placed into law, and they wanted to legalize recreational marijuana in the state of Michigan. A couple things are noteworthy about this. The first is, if you've been on Facebook at any point in time between, 2016 and now, getting an 11-point margin of anyone to agree on literally anything is nearly impossible. So that's noteworthy. But the second piece, I think, interacts with the discussion we just had about Ontario Smith, because that story was back in 2005. In 2005, of course, marijuana was unlawful except for medical usage everywhere in this country. So now I want you to flash forward to today's world and think about a world where this proposal has already passed, and think about whether or not Ontario Smith hypothetically was a member of your team. Imagine that Ontario Smith was your finest employee. And imagine that Ontario Smith was caught having violated a drug test or have tried to adulterate a drug test or something along those lines. And when you go to him to say, what's going on, Ontario? You're one of my best guys. He tells you, okay, fine, but look, it's lawful here. I've never had an attendance problem, you know that. I've never had a performance problem. You know that. I never fail to show up to work and do exactly what you tell me to do, and now it's lawful. What are you going to do with Ontario? And I will tell you that there are lots of people who will say in this room, oh yeah, for sure, we have a drug policy, we're going to follow it to the letter of the law. And I respect that. If that's what we want to do, we can. There are also going to be many of you who will be tempted in that particular scenario to make an exception for Ontario Smith. And that is the reason that we are here today, because this is the conundrum that many of you are quickly going to become placed in. So I want to give a little bit of a roadmap about how I want to break down and analyze this law. First, how did we get here? I want to talk a little bit about history of marijuana legislation in this country, not only because as a graduate from the history department at the University of Michigan, there's nothing else I could do with a history degree, but I need to get it out somehow. But also because I do think that it actually provides a helpful cultural map about the way that our impression, the public perception, the cultural taboo associated with recreational marijuana kind of declines and then increases and declines and increases throughout time. It's very easy to think the current cultural moment that we live in has been the moment we've always lived in. And that is not the case with this particular drug. The next thing we're going to do is we're going to analyze the use of marijuana by the numbers. And why are we going to do that? Isn't that really the work for a statistician, for an epidemiologist? I don't think that it is in this particular case because, of course, the workforce that is going to work for your company is made up of the people in the populace. How many people actually use marijuana? I will tell you that when I did the research for this particular area in preparation for this presentation back in December, I was absolutely shocked by some of the statistics that I found. I think you will be too. Then we're going to actually meet proposal one. I have found that we don't do enough actual analysis of what's in the law. What did we just make lawful? We'll go not provision by provision because that would be horrifically boring. I'm not that much of a law nerd, but we'll hit some of the highlights so that you guys can know not only what will impact employers, but also what is in the law from a broader societal perspective. Then we'll have a brief session about marijuana testing and monitoring so you can understand the dilemma that you are placed in by some imperfections in the testing technology. We will talk about what proposal one means for employers in legal terms. This will be a short section because I think what you really care about is what does proposal one mean for employers in practical terms. And that's how we'll wrap up, and then we'll have a little bit of time for questions. Cool, ready to go? Okay. So first, how did we get here? And this will be a short section, and please bear with me, even if you're the kind of person that really hated social studies in high school, because I think that this is actually sort of a fascinating study about the way public perception about marijuana has changed over the years. And I think that that becomes really evident when you look at these images about marijuana use and abuse in society. These are images that come from the 1920s, the 1930s, and the 1940s. And these images here depict the current cultural moment at that particular period of time about what a marijuana user looked like. Now, I'd like you to just perform a quick thought experiment and close your eyes and imagine using today's cultural moment. What does your stereotypical stoner look like? You don't really need to close your eyes. It's just one of those rhetorical devices. And imagine it in your head. And the person that you're all able to do it, first off. And the person that you're picturing in your head is probably Shaggy from Scooby-Doo, right? He's a guy that has trouble getting out of bed. He's inconsistent with his work. He might not really do any work at all. But he's laid back. He's chill. Maybe too chill. Maybe way too chill. Maybe not the guy you'd want running your machine press. But look at the image from the 20s and the 30s. Reefer madness. This picture will be shown to adults only. The deadly scourge that drags our children into the quagmires of degradation. Quagmires of Degradation is going to be the title of my new novel. The burning weed with its roots in hell, marijuana, a puff, a party, a tragedy, wild mad thrills, reefer. I'm going to just say what's very evident from reading between the lines. The image, the cultural image in the 1920s, the 1930s, and the 1940s is that marijuana would turn its users into hyper-aggressive, violent, sex-crazed criminals. The implicit assumption with this is that it would degrade our morals, and it would turn people literally into rapists. Now, look, I'm not a doctor, okay? I don't know very much about the actual scientific and sociological effects of marijuana on the human brain. The only thing that I use this image to do is to point out how different your impression about what a stoner is like today differs from the image about what it looked like back in the 20s, the 30s, and 40s. Both of those images are pretty negative, but they're very different kinds of negative. I don't think that anybody would call Shaggy from Scooby-Doo a deadly scourge that drags our children into the quagmires of degradation. We just, might not want to hire him to drive our truck. So what does that really look like? How did it become an unlawful drug? Well, the way that marijuana first became unlawful in this country was actually, interesting, on a state-by-state level. Various states began to outlaw the use of marijuana, either recreationally or medicinally or for any other purpose, kind of at the same time that those images of marijuana pervaded the cultural landscape. So throughout the 1940s and the 1950s, it becomes unlawful to use it in various different places. There's like a patchwork of different states, a patchwork of different laws. There's some federal law, but it's not uniform across the board. But then look at what happens immediately next. There's a revolution. So we came from reefer madness, and then there's a revolutionary reaction to reefer madness, and that is the counterculture. During the 1960s, an entirely new demographic of people started using marijuana in a very visible way. They were upper middle class college students. They were predominantly white, and they were using it visibly and frequently in places like, Ann Arbor, in Berkeley, California, over at Woodstock. It's popularized, too, by many cultural icons of the era. There's Jimi Hendrix. He's not afraid to be photographed smoking marijuana. It's super illegal at that point in time, almost everywhere, and yet he's going to do that. He's going to visibly use it. So there's a backlash to the original image that will follow shortly thereafter, however. And there's a counter-revolution that's embodied in the Federal Controlled Substances Act, which was passed in 1970, and which has gotten a little bit of a rough rap from pro-weed communities today because it was not designed as we intended, or that we understand it today, to be a tough-on-crime, hard-nosed bill. It was actually designed as a compromise piece of legislation. Because remember how I said that it had been outlawed state by state? That meant that there was an enormous disparity in how the possession, use, and sale of marijuana was criminalized in various different areas of the country. Penalties were extremely harsh in the American Southwest and in the American Deep South. However, penalties were extremely liberal in the Pacific Northwest. So as a result, the same action in two different states could give you anywhere from a period of probation or a suspension of driving privileges, something that is a civil in its sort of nature as a violation, to hard, long prison time in other areas of the country. So this was a bill that was designed to say, you know what we're going to do is we're going to normalize the way that drug laws get treated across the states. We're going to kind of set a minimum, and then we think that the uniformity will follow. Now, the Controlled Substances Act did categorize marijuana as a Schedule I drug. What does that mean? A Schedule I drug, and again, I am not here to change anybody's mind about marijuana or to adhere to the orthodoxy about marijuana. I don't have an opinion, but a Schedule I drug means, for better or for worse, whether or not you think it's a good thing that it's there or a bad thing that it's there, Schedule I drug means that it has no accepted medicinal use, and the possession and use must be criminalized, and in addition to both of those things, you can't get federal funding for doing any sort of study involving the use of marijuana, which is going to kind of come back to bite us in just a minute in a way that we'll learn about. By the way, if you take only one thing away from this, understand it is still categorized there, which means that, let it be clear and known, the possession, the use, or the sale of marijuana is unlawful under federal law, full stop. It still is. Nothing about the fact that Michigan has, as a state law, legalized the use of recreational marijuana, the use of recreational marijuana changes that. Okay, so there we are. Now we're in a period of high enforcement. In the 1970s, we're going to say, okay, it's been categorized, it's going to be uniform across the country, but then a very unusual thing happened that actually, again, this is a paradox to the Facebook situation we're currently in, where the right and the left can't agree on almost anything at all. There's this response that happens in a statistical basis, which is that the war on drugs occurs during the 1980s, and then there's a mixed effect that a lot of Americans begin to notice. And that's that the rate of incarceration in this country gets really, really high. Because we're actually enforcing the laws that are on the books in a way that maybe we hadn't prioritized as much before. And this is a actual paradoxical effect of kind of uniting both the political right and the political left. The political left looks at this and they say, think about all those people who have been deprived of their liberty. Think about all those people where this may be a due process issue. This is an issue about a cultural violation. And the right looks at this also and they say, look at all of those people and look at the enormous fiscal drain caused by the fact that we have to incarcerate all these Americans. And from that, our opinion of drugs, once again, kind of starts to change. Leads the public to begin reevaluating the attitudes towards marijuana. I think these are the two most interesting graphs, and they're side by side in the entire presentation. And I think I've got some pretty good graphs in this presentation, if I may say so myself. The one on the left is the U.S. public opinion on legalizing marijuana. It's conducted by the Pew Research Center, and they asked us a really simple question, but the benefit to it is they've been asking that really simple question since 1969. When they first started asking the question, 12% of Americans felt that marijuana should be made legal. Today, that number is 62%. That samples from the right, that samples from the left, that samples from places where it's already lawful, that samples from the Deep South, which used to super highly prioritize enforcement of it. And that isn't, by the way, just the fault of anybody who was born after 1982, because you could see that in the chart over on the right. When you take a look at attitudes divided down by generations, you notice a couple things that are interesting. First thing I would notice is that my overall thesis about how this waxes and wanes like a sine curve is kind of borne out. If we were to expand that, you could see, okay, it's higher and then it gets lower and now it's back up higher again. You can see a couple things that are interesting. That actually happens for each and every generation that is depicted. The silent majority, which is the generation of individuals that were born during the Great Depression up until the end of World War II, so the pre-baby boom generation, today 39% of people who belong to that generation believe that marijuana should be made lawful in this country. For millennials, the rate is currently 74%. 3/4 of them do. But again, everyone is on the uptick from the low point of that 1980s. That was that nadir. That was the moment of the war on drugs where, again, the public perception changes over time. So how did this begin to change? Well, California, predictably, perhaps, was the first state that led that change because in 1996, they decided through a ballot initiative to introduce medical marijuana legalization, and many other states followed. Michigan did in 2008. And you can see another interesting pattern. Remember how states were the first one to make it unlawful and then the federal government followed? Well, states are also then the first one to make it lawful, and that's the moment that we're living in. So you can see over time, the red dots demonstrate the states where medical marijuana becomes lawful. And you can see until 2012, when for the very first time, and everyone knows this because it's just one of those pieces of news that permeates everywhere, Colorado and Washington made it lawful to use recreationally. They just said, nope, you know what? We're not even going to bother with this medical marijuana sham. I don't use that word too lightly. I don't think that's breaking anybody's brain in this world right now to know that all the people out in California, I'm sure well, I'm not sure, but I think there are some legitimate medical uses of marijuana. But everybody with cards wasn't just using it because of medical uses. I hate to break it to you guys. This wasn't happening. So they said, you know what? Forget it. We'll just legalize the whole thing. You can use it, you can possess it, we don't care what the reason is anymore. And that happened in 2012, and then look what immediately followed. 2014, 3 more states, Alaska, Oregon, Washington, D.C. 2016, California, Maine, Massachusetts, Nevada. And then, of course, 2018, Michigan. So, that gets us up to the present day. Let's take a little bit of a look at marijuana use by the numbers. Why do we care? Because society is where your employees come from. Caveat before we begin on this, I am not a physician. No one would ever hire me as a physician. The reason that I went to law school was I did not like numbers, so that was not going to be particularly useful. But I'm also not a statistician for the same reason, and yet this is an area where it touches on the need to kind of do the sort of analysis. So I will tell you that in the process of developing this particular section, I did carefully vet sources, and I've also pruned and updated this from talking to individuals like physicians and law enforcement officers since that point. But this is going to capture some statistics about the current use of marijuana in this country. And because there's so much information out there, and it would take forever, and it would just be me spitting numbers at you, and no one would like that, I've tried to boil this down into 6 lessons about marijuana use in this country, and that's my gloss on it, but I'll provide you with the numbers, and you can make your own conclusion about what is true or not true. So, lesson 1, way more people use marijuana than you might think. And by you, I'm using you as a proxy for me, because when I saw that slide for the first time, I was like, oh, wow, that's a high number. So this is a poll that was conducted by Gallup, And they've been asking the same question again, and I think that's why it's valuable since 1969. And this is the question that they ask. I love this. Take the moment to follow along on your slides. It's great. This is the actual question. Keeping in mind that all of your answers in this survey are confidential, have you yourself ever happened to try marijuana? I love that so much. If I wrote in that level of passive voice in a brief, Keith would fire me. Has marijuana ever happened to you? Well, 4% of people back in 1969, the summer of love, it was the summer of love, 4% of people were willing to say that marijuana had ever happened to them before. Today, the number is 45%, and oh, look at that. There's a little hockey stick end to that. It's not a consistent curve, but goes up pretty sharply, and what would that year be? Look, it's 2012. Why is that significant? Because that is, of course, when Colorado and Washington were the first states that decided they were just going to legalize recreational marijuana. Now, I am not saying that this graph necessarily maps correctly onto the actual use of marijuana. Why? Because it's a survey question. There's a problem with survey questions, right? We don't have to be honest in response to a survey question. But two, what I think is significant about this is something that I hope to reveal in just a moment. Now, you guys aren't the first group that I'm going to do this to, okay? So, you know, it's happened to others before. And you don't have to answer the question that I'm about to pose to you. You don't got to do it. You can sit on your hands if you want to, and no one will assume anything at all. But I'm gonna put myself out there a little bit. I'm gonna ask you a question. So, has anyone in this room happened to have legal marijuana ever happen to them in any state where it was legal? I'm not asking you to admit to a crime, but I am saying, has anyone in this room happened to use marijuana for a recreational purpose in any state where it was legal? Please raise your hand if you're brave enough to do it. One! And then another person who is like, maybe I'll do it, but I'm not sure. Okay, look at that chart, and then look at this room, and then what we've really done is we've measured the rate of liars in this room. There are a couple things, but actually there's a lesson from this, and I think it's an important one, and I actually respect it quite a bit. Think about the context I'm asking the question. This is a room where you're surrounded by your colleagues. A lot of you are HR people who know that you have, drug policies in your workplace. But this is my point when I ask that question. You're an HR person, right? You think to yourself, I know my workforce, I know my employees, I know who they are. If you're willing to lie in front of HR professionals, they're willing to lie to you about the use, about their use in front of HR professionals, right? Because if that's what they're willing to say in a confidential setting about when marijuana happens to you, it happens to occur to them, when marijuana happens to them, they're going to lie to you if the question has ever come up in the workplace. That is the real lesson, I think, from that number and from that survey result, which is entirely consistent, by the way. The most I ever had was 5, and that was only because we were in like an auditorium-style seating situation, and all 5 people were in the front row. They couldn't tell, like no one else was volunteering it. So if I ever do this poll again, I need to do it heads up, 7-up style, you know what I'm talking about? We can actually break this down, though, with some more statistical surveys to actually measure use instead of measuring volunteering of use. Marist University conducted a study in 2016. It's really hard to do for the reason that marijuana is classified as a Schedule I drug. We can't get a lot of federal money to run, studies on its testing or implementation or use. But in 2016, Marist University did a study, and they determined, and I've looked at the reliability numbers, the N value on this study is extremely high, which means it probably doesn't have an artifact in it from a small sample size. Marist University concluded, based on their statistical study, that 55.6 million people have probably used marijuana once or twice in the last year. That would mean, if their conclusion is correct, and I think that it likely is, that about 18.5% of all U.S. residents have used marijuana within the past year, once or twice. If we go to within the last month, the number is probably about 34.3%, which would be 11.4% of all U.S. residents. Just over a tenth have actually used marijuana in the last month. Now, the National Institute on Drug Abuse is another kind of way of coming at the same numbers. And because of the way that they break down their classification, the predominant thing they're worried about is abuse of drugs by youth. So they carve things out in these cohorts, and it makes it kind of difficult for us to actually get a basis on knowing. But what they did was they studied 12th graders, and the National Institute on Drug Abuse back in 2017 concluded 45% of 12th graders report having ever used marijuana, so they had at some point in their life prior to that. 37% report having used it within the past year. 23% report having used it in the past month, and 6% report using it daily. That number shocked and surprised me. I thought that was extremely high. That was my perception and opinion. I went to high school in America too, so I knew that people smoked weed. I did not think that 6% of 12th graders were using it daily. That was my perception. Perhaps it's an artifact of, I'm a West Michigan guy too, so I came from here. Maybe it has to do with a cultural taboo, I don't know. But I do know that 12th graders are usually around the age of 18, which I do also know means they're about to become part of your labor pool. And that is what the statistics look like in 2017. Lesson 1, way more people use marijuana than you might think. Lesson 2, the availability of legal marijuana in the country is now staggering. We all notice this artifact like come around election time. You look at an election map, what it's shaded in, like county by county, it's either red or it's blue, and you're like, how does any Democrat ever get elected here? Because it's like a bright red map. Well, it's obviously because population density varies in different places. We have the same kind of artifact with marijuana legalization, because if you take a look at the map and you just see the states that are shaded in, it's like, not very much of the country, right? It's a couple states over there. The West Coast, nobody knows what they're doing, and then some other ones. Let's actually break that down in terms of numbers. 79.21 million Americans live in a state where recreational marijuana use is legalized. So 1/4 of our population, give or take, lives in a state where it is lawful under state law to use marijuana for literally any reason you want. 1/4. Also, 226.38 million Americans live in one state where it's either lawful to use it recreationally or medicinally. That would be 70% of the U.S. population. So the takeaway here is nearly 3/4 of the people in the United States live in a place where there is some way to lawfully consume marijuana for at least some people. Which, again, if you think about the cultural tide and you think about the other lesson from the history segment, where it's like the law follows the perception, I don't know what's going to happen next in the story, but I've got a good guess. Lesson 3, Americans use marijuana less frequently than alcohol, but only slightly less frequently than tobacco, especially for younger people. This shocked the heck out of me, but it didn't shock a lot of people that I've run this by that have teenagers, actually, who kind of know, yeah, apparently, I guess teenagers don't dip or smoke very often anymore, but it absolutely shocked me that those numbers were even comparable. Now, you're about to see some charts that, this is going to be really boring, I'm so sorry, but guys. You're about to see some charts that come from the National Institute of Drug Abuse Study. And those charts, unfortunately, don't give us overall rates. They don't give us rates in cohorts that make a lot of sense. Instead, what they do is they break down things into 3 groups: 12 to 17-year-olds, 18 to 26-year-olds, and 26-year-olds, people 26 years of age or older. Well, what that means is that I can't give you an exact number, some sort of like whiz-bang takeaway for this is people who are going to be old enough to typically get jobs and what the usage rate is. I am sorry. However, this helps us out a little bit. You see 2 numbers up there, that's because the National Institute of Drug Abuse tends to measure things state by state. So the number over on the left in each column, that is the lowest incidence state. So the state with the lowest incidence. The number on the high end is the one with the highest incidence state. There are 2 things that should stand out to you on this particular slide. The first being, the ballot initiative was billed here in Michigan as the coalition to regulate marijuana like alcohol. We don't use, in the state of Michigan, marijuana similar to the way we use alcohol. The usage rates are just not comparable. The usage rates for marijuana are much lower. But I did find the second number to be shocking, which is the numbers between marijuana and tobacco, especially in the 18 to 26-year-old cohort, are not really that dissimilar. Why is that useful? It's useful because marijuana use, up until it became lawful to be able to use it, and of course for the 18-year-olds, that also includes some unlawful users, because of course you can't recreationally use marijuana under the age of 21. But my point is, a lot of that use was covert, whereas I don't think very many people hide the fact that they smoke a cigarette if they do. We know that from the fact that our employees constantly assemble outside of the loading dock to do it, right? That's not a hidden thing that's secreted away. So if you want a rough proxy from the 18 to 26-year-old cohort and be like, how many of these guys smoke marijuana? It's about as many as you see smoking cigarettes, more or less. That's one piece. The second piece that I find fascinating is, look at the spread in these numbers. I guess I thought for some reason that people across the country, in the United States, would use drugs at pretty much the same rate everywhere. I wouldn't think there'd be that much regional variation. Some of these numbers have a huge spread. There's a state out there, and I don't know which one it is, where the 18 to 26-year-old cohort, there's 36% of people within that cohort had used alcohol within the last month. I went to high school here, and that was not the rate of people that were using alcohol within that cohort in the last month. I went to college here too. Come on, 36%. And that spread is really interesting to me, because that is another thing that we need to observe. So we can't always map what happened in other places onto what happened here. Quick takeaway. Lesson 4, but, and this is the corollary to the previous slide, I think, Americans use marijuana way more frequently than they use other hard drugs. That was the category. I grew up in the DARE era. I remember when the guys came into my classroom when I was a little kid and they talked about drugs, and marijuana was talked about the same way that we talked about heroin and meth and cocaine, okay? Maybe a lot of you feel that that should still be classified that way. Maybe a lot of you think that's an abomination. I'm not here to change minds, but that was the moment that I grew up in. The fact of the matter is, though, when it comes time to actually put the action where the talking is, people don't regard them the same way, no matter how they may say that they regard them. It's just to say, the usage rate of marijuana, the reason they've increased from the previous slide is we're talking yearly usage rates instead of monthly usage rates across those cohorts. You can see that the marijuana usage numbers are substantially higher than any of the other drugs, even when you measure highest incidence state to lowest incidence state. Lesson 4, Americans use marijuana far more frequently than other hard drugs. Lesson 5, and this is a no-duh slide, but wait, hold on, actually look at the numbers slide. Irregular use of marijuana increases after states legalize recreational use. Oh, no way. But look at the rate to which it increases, because I do think that is shocking. This is a good study for Colorado. Here's what they did. They measured it 3 years before it became legal, then they measured it 3 years after it became legal. Column on the left, 3 years before, column on the right, 3 years after. Again, broken down by cohort, because the National Institute of Drug Abuse isn't super employer-friendly and trying to estimate these out to the workplace. 12 to 17 cohort goes up by a 10, which, by the way, I'm sorry, that is a super sad number. 12 to 17-year-olds using it at rates that are that high. That's the only time I'm going to inject my own editorial opinion, but I was kind of shocked by that. They increase, but not substantially. And if you think about it, actually, that makes some sense, because maybe even as it becomes more available, it's still super unlawful for them to be using it just as much as it was before. From a legal perspective, in that cohort, nothing changed. It's not lawful for a 17-year-old to be using recreational marijuana anywhere. But in the 18 to 25 group, where there are people that can now use it lawfully, whereas they could not before, it increased by a third. The old rate in Colorado, 24.18%, increased to 31.75%, where we're talking about monthly marijuana use. But then look at the 26 and older cohort. The use literally doubled. The monthly use of marijuana in Colorado doubled in the 3 years after, measured against the 3 years prior to the legalization of recreational marijuana. So let's say that we commit an act of statistical malpractice and apply those rates of change to the Michigan rates. Let's just do that exercise, which if anybody has a Bachelor of Science in the room, they will want to get up and slay me with a trident for just making me propose this, but I'm a lawyer, it's the best I can do. Let's imagine that the rates from Michigan change at the same rate of change as in Colorado. These are the numbers that we'll look at in 3 years. Currently, in that 12 to 17-year-old cohort, 7.7% of 12 to 17-year-olds used marijuana within the last month in 2015. We would predict the number would increase to 8.4%. We're talking about the 18 to 25-year-old cohort, it was about a quarter had used it within the last month. We would predict that the rate would increase to 32.3%. Now, the 26 or older cohort, drum roll please, we were at 10% having used it within the past month. The number is now 20.1%. So again, 20.1% of people who are definitely supposed to be in the workforce are now, for a lot of you, if you have a drug-free workplace policy that is a strict interpretation one that includes THC, ineligible for employment at your company. 1/5 of the people 26 years of age or older. Lesson 6, yearly or monthly use doesn't necessarily correlate to daily or chronic use. I love the use of the word chronic in here. It was an inadvertent pun. Basically, what this slide is supposed to indicate, and using two different sources of numbers and trying to cram them together, as marijuana use overall increases, it tends to increase big time with folks that use it yearly or monthly, but doesn't tend to increase a lot the folks that were already using it daily. Let me put it another way. I like to call this the holiday party exception, because I had something absolutely unbelievable happen to me during Christmas in 2016. When I went out to Breckenridge, Colorado to go visit a fellow graduate of Columbia Law School, I went with him. He is married to a pharmacist who works with the Denver Nuggets. So this is a white collar couple through and through. You go to the holiday party, and I pulled up to their house, which is way nicer than mine. And I went inside, and on, you have the party tray, and you got the, like the carrots, the celery, no one's gonna eat. And then you got the holiday cookies, the vanilla ones, the big thick layer of frosting on it that tastes like garbage, but you eat them anyway for some reason. And then you had a bowl of edibles, and then you had the whiskey and the gin and the vodka. And then you had the bowl of edibles. Did everybody like fall asleep for a second there? That was a little bit of a mind-blowing experience for me. And like, they got kids, and like, the kids weren't around. I want to be clear about that. And like, no one went crazy, but that's just a part of the culture and society they live in now. These guys are highly functioning professionals. They go to work every day. I guarantee you, just knowing this guy, he was much more responsible than me. You should hire him as your lawyer. You can't, because you don't know what his name is. They did great. Also, he's only in the Colorado bar. This is a guy who's super responsible. He's a white-collar employee. I don't know if he's violating his employer's drug-free workplace policy, but I bet his employer doesn't either. The point being, the use of the infrequent use is going to increase. It does not necessarily mean that that couple is going to turn into everyday users, but it also means that that puts us in a little bit of a conundrum. We have an Ontario Smith problem here. So, okay, we talked about usage. I scared the hell out of you by bringing up a bunch of different statistics, and now we know this is like really super prevalent. What are we going to do about it? Let's actually meet the law, which I don't think that we've done enough work actually going through and learning. What do we just pass? First of all, and Keith already covered this, so I'm not going to belabor this point. Proposal 1 was an indirect initiated state statute. That means the following process is observed. A bunch of signatures are collected. Once the signatures are collected and it gets over a certain threshold, it goes to the legislature, and they're like, hey, you guys want to pass this? And a bunch of legislators took a look at it, and it's like, oh, a bill to make weed legal? Nah, no thanks. And then they put it on the ballot, and the voters approved it by that 11-point margin. What does that mean? Just like Keith said, it means that if we're going to amend the recreational marijuana law here in Michigan, a supermajority of the Michigan legislature is needed to do it. Then, think back to Facebook. A supermajority of people in this country can't agree about whether or not ice cream is awesome. We're not going to be able to amend that law. And when I say that, that's a little bit of a prognostication. Maybe we will be able to learn to amend it when the sine curve of our appreciation of it goes into decline. That might happen, but right now, ain't gonna happen. And I read a lot of articles and editorials and opinions immediately following the November election. People woke up and realized, what, weed is legal now? And a lot of editorials got written saying, okay, no big deal, we'll change it. It's gonna be really hard to change, at least in the short term. So point being, it's here to stay, at least for the short term. We need to decide what we're going to do. What does the law actually do? Section 5 is where the rubber hits the road. Makes it lawful for persons 21 years of age or older to possess, use, purchase, transport, or process, which I frankly don't know what that means, 2.5 ounces or less of marijuana. It's lawful to store up to 10 ounces in a home. When I put up the 2.5 and that 10 ounces, I'm not, like I'm not a baker by trade, so like I can't really estimate what that is. And I should have done this for today's presentation. If I put 2.5 ounces of parsley in a bag, you'd be like, what are you about to make? That is a lot of parsley, sir. If I put 10 ounces in a bag, you would think to yourself, you must be a parsley wholesaler. You must be a parsley farmer, sir. It is a lot of weed, and it is a much higher number at both of those thresholds than a lot of the other states that have passed similar provisions into law. Why? I don't know. That's the law. It is lawful to give any other person over the age of 21 up to 2.5 ounces of marijuana if you don't advertise or sell it. That is true right now, which has put us into an interesting bind because, of course, it isn't yet lawful to sell it. I feel a little bit like John Travolta and Samuel L. Jackson in the car in Pulp Fiction. It's like, it's lawful to use it, it's lawful to possess it, it's lawful to smoke it, but it's not lawful to But that last provision has put some folks into a little bit of a hazy interpretation. Here's a picture from the Ann Arbor News. Mark Bernard, owner of Smokes Chocolate, sits at a desk in his home office on February 9th in Ann Arbor. The company sells chocolate with free gifts of marijuana. I see what you did there. Section 10 makes it lawful to engage in commercial cultivation and sale of marijuana by licensed businesses. Section 7 through 9 requires LARA, the Department of Licensing and Regulatory Affairs of the state of Michigan, to create a state sale and cultivation licensing scheme. They're going to do this through the regulatory process. Section 11 includes specific prohibition on how marijuana growers and sellers may present themselves publicly to the public. And regardless of what your opinion is overall about the legalization of marijuana, I have an opinion which probably would surprise you if you knew what it was, given this presentation. But regardless, whatever, put that aside. If you go to Colorado, you need to go visit a recreational weed dispensary. You absolutely must go. I'm not saying you need to consume it. I'm not saying you need to buy it. I'm not saying you need to support it or like it, but it is the biggest mind-blowing experience you can ever possibly imagine. Here's what you do. You go into a room, they swipe your ID, you're in little tiny groups of 4. Then in those groups of 4 and of no more, you're taken back to another room, like it's an airlock on a spaceship, and you have to wait there. Then you're called back into a third room where a bunch of big glass counters are available, all of which have little different ways of selling and administering weed. There it is, and it's, I don't know, like it's plant form or whatever. There it is in edible form. There's a lot of different things, pre-rolled things. The guys behind the counters who are called bud tenders, which more than anything else make you want to reject this entire scheme. Bud tenders, come on. But. So it feels like you're doing something deeply illicit. It feels like you're doing something mega super unlawful. But everywhere on the walls, and you can kind of see it there, is the state seal of Colorado. There's their weed license. Here's a notice from the state of Colorado talking about how much is lawful to buy, how much is lawful to possess. Make sure you consume your marijuana safely. Here's a poster with a Colorado state deputy with like the hat with the hand on the car, being like, here's how to tell if you're too high to drive. And it's bizarre. It feels like this conflation of something that is brand new and groundbreaking with something that seems deeply illicit and creepy. It's like being in the movie Blade Runner. It's like you're in the future, but the future sucks. It's incredible. It's really groundbreaking, and you need to go if you have the opportunity to, because this is coming to Michigan. Section 4 provides a list of the things the law doesn't do. Here's what it doesn't permit. It doesn't allow you to drive a car or a snow machine, to fly an aircraft, to pilot a boat while under the influence of marijuana. What does that mean? We'll learn more in a moment. Or to consume marijuana while doing any of the same. Just like it's unlawful to have a roadie as a passenger in a car right now, it's also unlawful to take an edible as a passenger in a car right now, even if you're not driving. It's unlawful to give or sell marijuana to any person under the age of 21. Duh, because 21 is the threshold, the same as alcohol, about being able to consume. It's unlawful to possess, use, consume, or purchase marijuana if you're under the age of 21. It's unlawful to consume marijuana in a public place or on the property of anyone who prohibits it. On the property of anyone who prohibits it. Interesting. Do you have a parking lot at your facility? I was just going to hide in the car, man. Sorry, friend. I'm able to prohibit that on my premises. To possess marijuana in a school or corrections facility, even if it is being possessed by somebody who is lawfully able to possess it under different circumstances. And it's unlawful to possess more than 2.5 ounces in a residence without putting it in a secured or a locked container, because I'm sure that's going to be really easy to enforce. There are other assorted provisions too. So Section 6 has been, the media has not done a great job of communicating this. Section 6 allows localities to exempt themselves from it. And the way that this has been reported has suggested or implied very often that that means that various localities, like a municipality, a township, a city, county, can make it unlawful to smoke weed there. Not so. What that the locality can do is restrict or ban the use of marijuana businesses to be licensed there. As of February 12th, there are 219 localities around Michigan that opted to do that. And there are several big names in that list. Kentwood, right here in Wyoming, Walker, Grand Haven, Holland, Dearborn, Plymouth, and then elsewhere here in Kent County, Ada Township, Alpine Township, Cedar Springs, Rockford. There is a ring that is being created around Grand Rapids, by the way, pretty much in Kent County, so I know where the weed is going to be sold. Section 13 provides a 10% state excise tax, which, again, don't know why, is way lower than in a lot of the other states, bizarrely. The act doesn't change anything about the separate Michigan Medical Marijuana Act or any right or privilege afforded by that act. It does not result in an automatic expungement of prior marijuana-related convictions. So even though it's lawful to do it now, it doesn't mean we reset the clock, go back in time, and if you ever had a marijuana conviction before, it got expunged. Why? Because that would actually raise constitutional issues. The judicially imposed sentence was just cut off automatically by a ballot proposal. May that be changed by the legislature someday? I think there's a possibility it might, but it hasn't yet. The last piece, the state must start accepting licensing applications during or before December of 2019. Whenever I read that bullet point, I see like 3 or 4 people in the room, like, I've got an idea. Well, you probably already consumed your brownie if you're there. The point of the matter is, I will tell you, if you're thinking about it now, you're way behind schedule. You are. There are already people who have prepared themselves to implement their business, even though you can't even get a copy of a license application yet. The reason why this will be a big business here. Why? Because it's been a big business everywhere it's been legalized before. These are some pictures from Green Peak. If you're thinking to yourself that it's going to be like dirty and dank, I guess dank was again an inadvertent pun, look at how industrialized marijuana growing operations are preparing to be. This is going to be a huge deal in dollars and cents terms. Again, you can think whatever you want if you think about it. It is. It's coming. And we need to get ready as employers. Which leads me to my next slide, which is the challenges and the opportunities that involve drug testing. Remember I told you that the way that this is legalized here for recreational usage was by this coalition to treat marijuana like alcohol? Okay, there's a problem. And marijuana is really different from alcohol in one respect, and this is the respect that should be, if you are kept up at night, the thing that's keeping you up at night as an employer, which is, it is possible right now to tell whether or not someone is drunk right now. You can give them a breathalyzer. The alcohol content of their breath will be measured, depicted on the screen of the breathalyzer, and then you can even backgap it and look back in time to determine when they started drinking if you know how much they drank, and you know things like their weight and their size. Ah, okay, a wonderful tool. No equivalent tool exists for marijuana. We do not have any test that is currently able to determine whether or not someone is high right now. Big problem, right? It is a big problem. And I think that that is the careful distinction, which is the employment issue in a nutshell. Because marijuana stays in the system for a long time. For a urine test, it could be for up to 13 days. For a hair test, it could be up to 30 days after the use. By the way, we have a lot of people who attend these seminars who are members of drug testing companies. I needed to revise this slide like a billion times because I had people come up to me and be like, oh, no, I have a product that can do it in XYZ. And I'm like, okay, we'll change it. There are also oral swab tests that are now available, which is the vanguard of technology. This is the most up-to-date way to be able to test for marijuana use in the body. But they test, too, for recent ingestion, not impairment. So a little swab, you put it in your mouth, and then run it through, put it into a machine. Machine tests for the presence of either the active or the expired metabolite in the mouth. Meaning that if you've consumed it within the last, and again, this is one where you see a wide range of different possibilities, the median tends to be within the last 12 to 20 hours, you'll get a positive result. Now, that is way closer. Now we're super close to the time of ingestion. We're outside of the urine or hair test problem. 12 to 20 hours still leaves us open to the thing that may tug at the heartstrings sometimes at various employers, which is your best employee, your Ontario Smith moment, but I used it last night, I've never been high at work, I would never come drunk to work. Come on. Well, we don't yet have a way of being able to know. And that is the problem that we find ourselves in to the extent that we really want to make sure that we maximize their ability to prove impairment at the time. So a couple things. These are points that we can remember. Remember how I said if you only take away one thing? These are the other points that if you only take away a couple of points from today's presentation, these should be on that list. Although there's no federal law that directly regulates drug testing per se in terms of what you must not do, the same way that there is, of course, restraints on ADA testing of alcohol, but that's for another presentation. Do remember, if you have DOT-covered employees, let me say it loud and clear. If you have DOT-covered employees, the only answer for those particular employees is zero tolerance. There is no other way to go. Why is that? Because it is still unlawful under federal law. Full stop. That also, of course, includes the safety-sensitive employees, as that term is defined by the Department of Transportation regulations. So if you are a company and you have drivers, the answer's been made for you. You've got to deal with the backlash still, the practical effect, but there you go. And also, there is a federal law that applies to federal contractors, the Drug-Free Workplaces Act. That also, same story. You're a federal contractor that is covered by that particular act. The employees that work in the portion of the operation controlled by those provisions, also zero tolerance is the only answer there. Okay, so now we're all thinking back, and we're all trying to scramble to remember, like, oh gosh, what's my drug testing policy say? Oh my gosh, what does it say? Okay, so we have a lot of us reasonable suspicion policies, right? Well, reasonable suspicion policies rely on us to be able to use objective evidence of one form of another, and then to determine whether or not a person who is reasonably and carefully and even-handedly applying that evidence would be able to suggest that a person is under the influence. But what is the method and the means by which we're able to detect when an employee might be under the influence of marijuana? That's the problem with the covert use, right? In the very first thought experiment was when I made you all volunteer to participate in my social studies experiment about volunteering for who uses marijuana or has used marijuana before. It's hard to know as a person who is beginning to experience and think about this issue for the first time, exactly what the reliable actual medical symptoms of marijuana impairment are as exhibited. But I've developed this list and again, changed it several times after talking to law enforcement officers and physicians. And these are the most common answers that I receive. The inability to remember instructions, inattentiveness, impaired judgment, uneasy coordination, impaired balance, inexplicable anxiety or paranoia, which I have all the time, by the way, attendance problems, timeliness issues at work. Those are the symptoms to remember and to check off, and they're useful in two ways. One, it helps you to know what are the things that I should be looking for if I have a reasonable suspicion drug testing policy to prompt me to suggest maybe a THC test is warranted. That's one piece. Then the other piece is when it comes to document the reason for the test, presuming, of course, that any of those were actually present. We don't document things that aren't true, but those are some of the things that need to go into your documentation. Helps you out in both ways. So, employer legal update. What does the law require us to do? Again, a short section. Why is that? Well, it's because Section 4.2 of Proposal 1 provides the following. This act does not prohibit an employer from disciplining an employee for violation of a workplace drug policy, there's one provision, or for working while under the influence of marijuana. And this act does not require an employer to permit or accommodate, and I love the word accommodate there. Why? Because it appears in the ADA. Does not require an employer to permit or accommodate conduct otherwise allowed by this act in any workplace on the employer's property. Sounds great, right? And I agree, it is great. I'm about to nitpick these because if I were representing a chamber of commerce, and I do, I represent management. So if I were to have drafted this law, I would want to make it safer for you as an employer, but it's pretty good. I give this a B+ or an A- in terms of the degree of protection that it gives to employers. But I'm a lawyer, I look for potential areas of risk, and the courts have not yet interpreted this, right? Because it's brand new. Same problem that Keith was describing. We were talking about the medical leave law. Okay, so if we compare that to the equivalent language in the MMML, that's helpful actually because, of course, the Michigan medical marijuana law has been held by the courts already to mean that it does not abrogate an employer right. Remember that Cassius versus Walmart case? It was like it was the big issue in 2012. Like, do we have to accommodate an employee's medical marijuana card? I'm a card holder. I can lawfully consume it at work. No, we have the discretion to be able to decide whether or not we want to tolerate that, and if we don't, to discipline you as a result of using medical marijuana or having the metabolite even in your system, even if you're a card holder. That's what that law told us. So it's different language, so the answer isn't necessarily the same. We don't know what the language from the recreational marijuana law means yet. Again, courts interpret the law, not enough time has passed to allow them to rule on this. But here's what it probably means. There's no duty for employers, probably, to accommodate medical or recreational marijuana use either under the ADA or under any other statute. That is what it probably means. In other words, it probably means if you have a drug testing policy that says you can't be at work with the active metabolite in your system, it doesn't matter anymore whether you're under the influence, I can fire you. That's what that probably means, which should give you a high degree of comfort because it probably means you can make the discretionary judgments you want to make with your workforce. But I'm a lawyer, so I can't go without ruining things for you. I'm so sorry. What is less clear? Okay, remember how we had those two conditions? The statute said an employer can discipline or discharge an employee for either of these two reasons. Well, if I put on my plaintiff's counsel hat, the grimiest hat of all, and I think to myself, how would I try to get around this? I would say, well, it says you can discipline for those two reasons. That must mean, as plaintiff's counsel might say, you can't discipline or discharge for any other reason. And here are the two reasons. Each of them are a little bit problematic. One, it doesn't prohibit an employer from disciplining an employee for violation of a workplace drug policy. Okay, well, one, what if you fire an at-will employee for testing positive on a THC drug screen? Do we have to prove that our policy prohibited it? Again, I think that the answer is no. I do not think you will have to prove the policy prohibited it, but I am telling you that a lot of people are coming up to me after this presentation and saying, we don't have a drug policy. And I'm like, see me after class. This is the time now to do one of two things, okay? You've been given an exemption where you can draft a policy or revise your policy to make sure it says what you want it to say. Take the time now to visit it, and if you don't have one, it also definitely means you need to have a policy if you don't already for that reason. Or this is the other option that you're able to discipline or discharge an employee for, under my plaintiff's counsel hat, for working while under the influence of marijuana. Well, what does that mean? We've already proven we don't know how to test for current impairment. Now, one way that I would suggest maybe thinking about, what about if in our drug policy we defined being under the influence as having the presence of the active or passive metabolite in the system? They'll be like, but I wasn't high right now. It's like, no, under the influence in this policy means you had it in your system and you did, so I don't care if you're high right now or not, I'm using that to qualify and count. That's the belt and suspenders approach, and I really want to recenter you. I am telling you that I don't think that this language presents a problem for you, but it may, and these are the kinds of steps that you can do to maximize the reduction of liability risk for you as an employer. One risk is evident also. Whatever method we choose, whatever we do with our drug testing policy, we can't apply it discriminatorily or selectively without potentially incurring significant liability. There's this case, Berry versus ArcelorMittal, which is a Northern District of Indiana case. Note that it is not an area where recreational weed is lawful. Here are the facts of this case, and I think it kind of presents the issue for you. There are two employees who are involved in an altercation. Big old fight in the shop floor, like pow, pow. Black employee is forced to get post-accident tested. The white employee is not. What were to happen if the black employee were to get terminated, but the white employee were not, especially if it could be proven the white employee was also under the influence at the time, they just didn't bother to test that person? I don't know. The court didn't reach a conclusion. The employer is saved, but only because it had documented those reasonable suspicion standards in the documentation of why they sent the African-American employee for drug testing, whereas they demonstrated in their documentation the white employee did not exhibit those signs. Helpful, also a warning shot for you guys. Point being, imagine that we did the following. We randomly test all of our employees for THC, okay? Then we get a list of positive results, and we only terminate the poor performers. I'm going to put back on my plaintiff's counsel hat. I'm so sorry to do this to you. If I can go through those two lists, so I've got a list of all the employees who tested positive that you didn't fire, and all of the employees that tested positive that you did fire, and I compare the two next to each other, and I find a protected category that the people on this list share that the people on this list didn't, you might have yourselves a problem. Point being, fundamentally, whatever method we choose, we need to apply it discriminatorily or selectively. We can't do that. And the only reason that I point that out is because so many people are like, well, I'll just put whatever I want in the drug testing policy, and then if Jerry, who's my best machine press operator, tests, I mean, I know, look, he smokes weed in his trailer on Saturdays, I don't care. I'm not going to fire him. Be careful. Be careful about adopting an approach of selective enforcement. Would that ever be a good idea for any other HR function? No. March 2018, this is the practical component, and this is where we end our journey together. The U.S. unemployment rate hovered at 4.1%, that was the lowest since 2000. So what? Well, near full employment means more challenge for you as an HR professional. Why? Because the number of qualified and available applicants is rapidly shrinking. So you're going to have more and more difficulty finding people to come into jobs, especially disproportionately in certain industries where there are some employees who are lower skilled that make up the majority of our workforce. I'm not telling you guys anything you don't already know, but think about the ramification of this. The rate of illicit drug use among full-time employees is about 9%. That's already substantial, but positive test results are going to increase. Look at the results. There is a 20% increase in positive test results in Colorado after legalization. There was a 23% increase in Washington after legalization, and, drumroll please, there was a 43% increase in Nevada. Now imagine if your policy makes it so that anybody who tests positive on a pre-employment drug screen can't work here, and imagine that you have your operations in Reno, Nevada. Enjoy. Because all of a sudden, a dreadful unemployment rate from the perspective of an employer has just gotten 43% worse. What is this all going to mean? It's going to mean that it's going to be harder to retain and hire qualified individuals because fewer and fewer, not less and less, I need to fix that typo, fewer and fewer of these individuals will be able to pass a drug test. And that's the practical impact piece. Guys, you can think whatever you want. You can decide whatever strategic approach you want to adopt. A lot of those approaches are going to be lawful, and that's awesome. But that is a practical impediment, and we would be putting our heads in the sand to ignore that it is occurring. So as we see it at the firm, I think there are three options, okay? These are options A, B, and C. Option one, if you have a 1995 drug-free workplace policy where if you test positive on a pre-employment drug screen for THC, or a reasonable suspicion drug test is ordered and comes back positive, or you do post-accident testing and that comes back positive, you're fired, you're done, you're ineligible for employment. Is that lawful? Absolutely. Yes, it's very likely a totally lawful approach. No law is going to prohibit you from drug testing or declining to hire applicants who test positive for marijuana. The problem is going to be an economic one. We all remember economics from 12th grade or from an economics class we took in college. Your demand of hiring remains the same. The supply of employees just decreased by 43%. If demand remains the same and supply has reduced by 43%, what increases? Wages. Bingo. So imagine in this hypothetical chart, I don't know, that is your employer base. And imagine those are the percentages of people who are ineligible for your job on top of the unemployment situation you currently find yourself in. Guys, I have tons of construction contractors and manufacturing owners in particular who come up to me and they say to me after these presentations, look, Andrew, I have never one time voted for a Democrat in my life. I don't care about this issue culturally. I do not allow weed in my house. I don't want my kids to smoke it. I've never smoked it. I don't respect anybody who does. But I know that all of my roofers or all of my line workers get high every single weekend, and I don't want to have to hire an entirely new slate of employees. What am I going to do? Well, I mean, overall, I think you do have these three choices. The first is you do it, you turn over, and you deal with it. That's one option, and I think it's a perfectly valid option. Some employers are, of course, required to prohibit drug use as a condition of employment. We talked about the federal contractors. We talked about the DOT-covered employees. And then certain safety positions also have a practical requirement, right? The guy operating the machine press from 8 Mile where you push down the sticks and the enormous 8,000-ton machine comes down and crushes you. If it's better safe than sorry to a degree of safety above all else, isn't there kind of a practical requirement in there? I can see adopting this drug-free workplace policy regardless of what the economic cost is, because the cost of doing the alternative would be so much higher. And maybe because it's the right thing to do, and certainly where it is lawful to do it. And I'm sorry, mandated by law to do it. Option two, and some employers are also electing to take this, you can maintain pre-employment screening, but eliminate THC marijuana metabolites from the screened substances. So you could do like, instead of a 5 and 10 panel test, that used to be the typical thing that a drug testing company would provide as the default option. A lot of companies now are offering 4 and 9 panel tests. What's the panel test they got rid of? THC. Now, of course, even if you do that, I would still recommend that you test for marijuana with reasonable suspicion of marijuana intoxication, because let's put a pin in this too. No one should ever be under the influence at work for any reason in your job. We just talked, though, about how difficult that is to tell. So we could change our pre-employment screening policy to use a different test. We could maintain the use of THC testing with our post-accident or reasonable suspicion testing. Also a possibility. The strength, it treats marijuana like alcohol. The weaknesses, although not all marijuana users are chronic users, you're losing a tool that could be useful to tell if you're hiring Shaggy from Scooby-Doo, maybe. Do you want him working in even a non-safety sensitive position? Are you eliminating a tool to screen out poor performers if you do this? I think you might be. Option 3, you can stop pre-screening or random drug testing at all and maintain only reasonable suspicion or post-accident drug testing policies. A lot of people in this room are going to be like, Andrew, that's crazy. Well, okay, I kind of think, frankly, that it is too. That's just my opinion. That's not the position of the firm necessarily, but it might be right for some employers, and the reason that I know that is that a lot of employers are electing to do this. The strength is certainly a lot cheaper, and it'll also dissuade the Friday night users from not applying at all to the job in knowledge that they're going to get, I almost said weeded out, like unironically. The weaknesses, of course, if marijuana is no longer an heuristic to weed out poor performers, oh, okay, it's on the slide, great. Is that true of meth or heroin? No, it's not. Or I should say, I haven't done the same statistical analysis, but I really don't think that it is. So is eliminating even looking for that a good idea? Maybe it is for your company, I don't know. Certain jobs, of course, must or should be subject to testing because of either illegal or practical requirement. So, final takeaways from this whole thing. Last slide, I promise. I know I've been talking for a billion years. Number 1, regardless of whether or not you had an employee drug testing or prohibition policy, every employer needs to at least revisit those policies now. If you don't have one, get one. Even if you do have one and you haven't thought about it, dust it off. Is it doing what I want it to do? If it is, great. If it isn't, then revise it. 2, no employer should ever allow employees to work while under the influence of any intoxicating drugs, marijuana included. Don't want to lose the forest for the trees here. Again, I keep making these marijuana puns. There's trees. But the point is, under the influence behavior and activity is not something that any employer should condone, right? We're all on the same page about that one, right? Whatever policy you adopt, apply it even-handedly. That's another key component. And then whatever policy you adopt, have it align with your organization's mission and philosophical goals. And that's my advice, I suppose. Start big to small. What do we want our overall strategic approach to be? Then we take a look at the policy. Does it already do it? If it doesn't, we revise it so that it does. And I think that is the path out of the practical trap that marijuana legalization in Michigan has set for us. That's all I have.
Here's my proposal that we stick on marijuana questions for maybe 10 minutes, and then we'll stay focused there, and then Keith will come up, and then we'll take any questions. All right,
for me.
Who wants to get started?
Marijuana workplace policy questions, please. I can't answer.
Oh, yes.
Will workman's comp insurance companies have anything to say about our policy?
They certainly will, is my prediction. Now, I've talked with various work comp insurers who've built in some actuarial calculations and how this will impact things moving forward. I will tell you that that work has already begun. Now, how is the tail going to wag the dog in terms of what we're allowed to put in our workplace policies as determined by our work comp coverage, but I'm not sure which one's the tail and which one's the dog. Just to say, is it going to raise the actuarial risk of changing a workplace drug policy? It could. I've begun to see changes in that regard. But what I can tell you is the various methods that I've talked about changing drug policies to be more lenient with THC, those were the changes in policies, by the way. There's several slides I wasn't able to include in this that were in my longer presentation. The number of, for example, employers in the state of Colorado who used to drug test, these are numbers off the top of my head, but they're roughly accurate, used to do for pre-employment screening about 85%. Today, it's about 61%. Now, surely the work comp insurers in that state have already incorporated actuarial assumptions and the actual data to try to determine and nudge the policy in a certain direction, because the work comp carrier determines in part what your policies say, right? You can adopt a policy, get a lower contribution rate or whatever that it might be, you're probably going to do it. So what's the direct answer to your question? Yes, they're going to have a say in it. What is that going to do, and how is that going to change our calculus? Hard to say. But the technique has been, I have seen in other states, the overall trend seems to be that employers respond by being more lenient. Maybe we're going to learn in 10 years that's the worst possible thing in the world. I don't know. That has been the historical pattern we've seen in other states. Anybody else? It was just that comprehensive, huh? I mean, come on.
Well, Keith, why don't you come on up and we can start taking medical leave questions as well. Are there any questions for either Keith or Andrew?
You
did hear him say he has a longer version of that. So.
While you're thinking of your questions, let me do a quick commercial on your way out. Make sure you get your bag of brownies and candy. Also, there are posters or little cards for all of our summits. I'd mentioned this earlier, ovdinsurance.com/summits. You'll find the information there as well as how to register. All right, who's got the next question?
I think that you're talking about the recreation, from a recreational marijuana perspective. The question was, what do multi-state employers do? You guys are in a real pickle, and here's why. It's actually it has two aspects to it. The first aspect that's important is the obvious one. It is not lawful to use in other states, so it would be crazy for us to adopt our policies for a statistical and demographic change we haven't yet seen, when obviously reducing the number of potential drug users in our workplace creates the biggest safety benefit. But there's another part too, which is there are several states in our country that have laws about whether or not off-duty conduct can be considered as a condition of employment. Michigan is not one of those states that has such a law, although there are certainly reasons why you may not want to consider it. I think it's New York, and there's another New England state that has a similar law. Those are sites where I think that this problem is going to become like a major league issue, because then the question becomes, now that we're not able to tell, did you smoke weed here at work or did you smoke weed off work last night? And one is illegal to consider and one is not. That is where the real rubber needs to hit the road. But thankfully, there is not yet a state that has both lawful marijuana use and an off-duty conduct prohibition law. Yeah, but it's coming. There are also other states that are important to remember that have laws about various places where conduct can be considered. For example, Indiana has something about a smoking in parking lot prohibition law, things like that, smokers' rights laws. Those don't typically apply to marijuana and don't yet in any state where those are present. Will there be some sort of carve-out in those states for marijuana? I don't know. I think one other thing that we can think about is it's not unlawful for us to have different policies that cover employee groups in different states. And I think that's medical leave.
Right. So remember, the Michigan paid medical leave only applies to your employees predominantly in Michigan. So you're only going to need to have the policy apply likely to your Michigan operations, unless you're in a situation where you've got people that live in Ohio but predominantly work here. I can't imagine a situation where they predominantly work here, they're covered by your Michigan policy. So it shouldn't be an issue. But I would recommend what Andrew said, which is look at each state specifically to make sure you're compliant with whatever policy you adopt. And one thing I do want to mention, Andrew said that ADA accommodation, we don't think you have to accommodate drug use. On a state-specific note here, I think we're going to see this challenge under the Michigan Persons with Disabilities Act, because it is unclear, and there's a case, I think, in Connecticut, where they said it was a reasonable accommodation in the state law context. So I guess my advertisement is, if an employee says, I need this as an accommodation, say, well, you don't need it under the ADA, and hopefully it goes away. But if they start chiming in and saying, no, under the Michigan Persons with Disabilities Civil Rights Act, I have this right, call us.
Yes.
Call us so we can manage that and make sure we minimize your risk.
Because now,
some plaintiffs' lawyers are going to go that route. It's just a matter of time.
Yes.
With this paid medical leave, talking to employers, do you find that they're just changing their vacation to PTO, or are they giving them additional medical leave?
I think the majority of what we are doing is taking existing vacation policies and adopting them to make sure that you can use them for the stated reasons in the law, as well as dealing with that gap, that first year gap, folks. That's what we're seeing the most of, yes.
Worried how employees are going to take that as it rolls out, that they're not really getting any benefit from that.
And that's a great point. I mean, legally and cost-wise, that's the best approach for businesses. If you feel like you have an employee engagement issue and that strategy is going to backfire on you, and that might look tell employees, hey, maybe we need a union, that sort of thing. If you're in a workplace like that where you have strained relations, then that's a different, something to think about. But I gotta believe that, if you have good employee engagement with your employees, that's not gonna be a huge thing for them. They're gonna be happy they can use, the leave.
It's been wonderful. Andrew, thank you. In your packet, if the last couple pages, you notice their bio, their contact information is there. When should they call you?
All the time. As often as possible. Call early enough.
All right, and then may I offer you for the next maybe 10 minutes, one-on-one questions? Excellent. Thank you for coming. Grab the goodies on the way out. Thank you again.
Talk about sample policies, is that something we call you about?
Yeah, give me a call. Or if you want to shoot us over here, I can give you a card if you want. Or you got my, yeah.